Hello friends, this is Dr. Sumiti Ahuja and I am Assistant Professor at Faculty of Law, University of Delhi. Coming back to the further provisions which defendant had referred to for getting the repayment of the amount advanced, next was 68. 68 is claim for necessaries or liability of a minor under section 68. It says claim for necessaries supplied to a person who is incapable of contracting or on his account. If a person incapable of entering into a contract or anyone whom he is legally bound to support is supplied by another person with necessaries suited to his condition in life, the person who has furnished such supplies is entitled to be reimbursed from the property of such incapable person. So, the defendant, the money lender said, if nothing else, if no 64, no 65, can I get relief under 68? Because I have provided the minor with something and now which was a necessity and I should be reimbursed from his property. Now, the court said, what is the meaning of necessaries suited to minor's condition in life? Necessary means basic requirements. What kind of basic necessity you have provided the minor with? Now, section 68 is one of the forms of quasi contract. In our last session of this course, we would be discussing the concept of quasi contracts and we will get into the details of section 68 again. But for the time being, you need to understand that the court made it very clear that section 68 cannot come to your rescue or cannot favor you, if I may say, because you have not provided the minor with any basic necessity which is suited to his condition in life. So, you cannot get any relief in a way under the Indian Contract Act. Now, what else is left? Now, he stated, okay, if Indian Contract Act cannot come to my rescue, can I get relief under section 41 of the Specific Relief Act 1877? Because Mohri Bibi's judgment is of 1903. At that time, we were having this old Specific Relief Act which came in force in 1877. Now, we have a new act which has replaced the old Specific Relief Act. So, what the section 41 of the old Specific Relief Act stated? It stated that on adjudging the cancellation of an instrument, the court may require the party to whom such relief is granted to make any compensation to the other which justice may require. It simply means if you are going to the court and you are claiming some kind of remedy from the court, if you have been benefited anyhow from that transaction, so before the court cancels that instrument, before the court grants you relief, you first have to restore, you first have to basically compensate the other person because you cannot be unjustly benefited. So, in crimes we talk about this concept of double jeopardy. A person cannot be punished twice for the same act. So, here a person cannot be favored twice for the same act. So, if you are cancelling the instrument, it would be in favor of that minor only, and if also you are not and if you are letting the person, the incompetent person here keep that property also with him, that keep that money or keep that thing with him without restoring that benefit, that will be like double favor, right. So, the law was very clear about it. If you are going to the court, you want to get it cancelled, please first return the benefit which you have received, or just make any compensation to the other party which justice may require, that is which the court thinks is suited for that case. So, basically ultimately no relief was granted to the defendant in Mohri Bibi. Now, before I end this particular discussion on this judgment of Mohri Bibi versus Dharmadas Ghosh, I would just like to highlight one thing. You may be wondering that I told you that Brahmodat was the money lender, so he became the defendant. Kedarnath was the attorney of Brahmodat, from where and Dharmadas Ghosh was the minor. So, from where did this Mohri Bibi came into picture? Mohri Bibi was the wife of the money lender who was the defendant, and she substituted him, because when this matter went to the stage of went to the Privy Council for the decision, till that time Brahmodat, the money lender, the defendant, was no more. Therefore, he was substituted by his wife. So, Mohri Bibi was the wife. Now, we had just had a discussion about the doctrine of restitution as was laid down in the judgment of Leslie versus Shell. Now, Khangul versus Lakha Singh, an Indian judgment of that time, it was very crucial also, you can say criticized also, you can say landmark judgment as well. But what made it so important judgment that despite being such an old decision, we are still discussing it? Because Mohri Bibi, we know, Mohri Bibi was that first judgment which said that minor's agreement is void ab initio. But from where did this Khangul versus Lakha Singh come into picture? Let's see. In Khangul versus Lakha Singh, the defendant, who was a minor, fraudulently concealed his age and contracted to sell a plot of land to the plaintiff. After having received the consideration of rupees 17,500, he refused to perform his obligation. That is, the other person has fulfilled the obligation, has fulfilled the promise, but when it came to you to fulfill your part of the obligation, you refused to perform the obligation. So, obviously, that other person, the other party, does not have any other option but to approach the court. So, the plaintiff here approached the court and he prayed for recovery of the consideration advanced, that is rupees 17,500. Now, Mohri Bibi had come into picture. Mohri Bibi said that yes, if that be the thing. See, Mohri Bibi, the situation was that minor was not asked to return that amount to him, because the thing was that the minor could have been compelled or could have been asked to compensate, because the law clearly stated if you are going to the court for cancellation of the deed, the legal document, you have to compensate the other party. But you must be wondering that I did not mention this thing, that why under section 41 of then specific relief act the court did not grant any relief? The answer to that is that the money lender, the defendant, was imputed with the knowledge that when he was entering into that transaction, that agreement with the minor, he was aware of the fact, very well aware of the fact that the other side, the other party was a minor. Still he chose to continue with this decision. The court said you cannot take advantage of your own wrong. You acted smartly, despite knowing that he was a minor, you still wanted to do that transaction. Now you will have to face the consequences. The reason in that case was that otherwise he would have got the relief. The defendant would have got the relief under section 41. Now here in Khangul versus Lakha Singh, you are clearly seeing that minor in this case was a defendant. He was not the plaintiff. So 64, 65, 68 of the Indian Contract Act being ruled out, the only thing left was section 41 of the Specific Relief Act. Now, section 41 of the Specific Relief Act also did not come to the relief here of the plaintiff, as it did not deal with the situation where minor was defendant. We just saw here that under section 41, it was only dealing with the situation wherein a person is approaching the court, the minor here say is approaching the court for cancelling of the instrument. Situation wherein minor is defendant was not being dealt anywhere, neither in Indian Contract Act nor under the Specific Relief Act. Nor was the principle laid down in Leslie held to be applicable in the case, as it did not apply to cases involving money. Remember Leslie versus Shell, Doctrine of Restitution, if the good or the property is traceable in possession of the minor, it has to be restored. But if the same is not traceable in the possession of the minor cannot be compelled to restore it, because it will amount to enforcing it. right? So even that doctrine of restitution as laid down in Leslie versus Shell did not come to the rescue, or did not come to, could not be applied in this case, if I may say. Now the judge in Khangul versus Lakha Singh was of the view that there should be greater scope of the doctrine of restitution in India, because compared to England, that is in English law, because in former, that is in India, all agreements made by minor are void, whereas in the latter, that is under English law, it was not the case. So what happened in the judgment of Khangul versus Lakha Singh is that court went beyond the doctrine of restitution as was laid down in Leslie versus Shell and held that the minor, even if the minor is defendant, because he acted in a fraudulent manner, is supposed to restore the money which he had received from the plaintiff. So minor was made to return that money back. Now the third case which I would like to highlight here is Ajudhya Prasad versus Chandan Lal, which came after Khangul versus Lakha Singh, which was 1920s judgment of Lahore High Court. This judgment was given by Allahabad High Court in 1937. Now Khangul opinion was not followed in the judgment of Ajudhya Prasad versus Chandan Lal. In this judgment, in this case, the facts were that the two minors had borrowed money under mortgage deed and they fraudulently concealed that they had a guardian appointed for them. That means these two minors, they were more than 18 years of age but less than 21, and they had hidden this particular fact from the other party when they had entered into this mortgage deed and had borrowed money. Now the court held that where property is not traceable and only way to grant compensation would be by money decree, decreeing the same would be equivalent to enforcing minors' pecuniary, that is monetary liability under contract, which is void. That means in this judgment again Mohri Bibi, that is minors agreement, is void ab initio, and the concept, the doctrine of restitution as was laid down in Leslie versus Shell had come into picture, because in Leslie versus Shell also something which is not traceable in the possession cannot be minor cannot be compelled to restore.